Hi, my name is Emily Calvin. I'm a Florida licensed attorney practicing family law and specializing in domestic and intimate partner violence cases. This is another informational video and part of the series I've been working on about stay-at-home parents and their rights in family court. Today, we're going to talk about child support. Under Florida law, child support is considered to be the legal right of the child and the duty or obligation of the legal parent or parents. What that means is the parents are not legally allowed to waive or contract away child support because the right belongs to the child, not the parents. Child support in Florida is calculated according to what's called the child support guidelines. It's a statutory formula that the courts have to use in order to determine what a parent's child support obligation would be. And you start with the parent's net income and you determine how many overnights each parent has. And depending on the percentage of overnights, as well as any sort of expenses that the parents pay out of pocket for things like medical insurance, co-pays, and childcare costs, you plug all these numbers into the formula and it spits out an obligation that one parent will owe the other parent on a monthly basis. That is pretty much the number the court is going to be stuck with. The court is only allowed to deviate over 5% from that obligation if one or both parents files a motion to deviate and presents some sort of good cause for that deviation. A question I get a lot from my stay-at-home parent clients is, I don't work, I don't have an income. What do I do then? What the court will usually do is called an imputation of income. Technically, in order for the court to impute income to a party that is not working, the court has to find that the party is mentally and physically capable of working full-time and that the party is voluntarily under or unemployed. Even if the agreement between the parties was that you would stay home and raise the children while the other parent would work, now that you're in family court, it doesn't matter. If you are able to work, the court will impute an income to you. Generally, they will impute a full-time minimum wage income, but there is the ability for the court to impute a higher income based on either, let's say you worked during the relationship at some point, some sort of current earning capacity based on historical earnings, or the court can use the median income based on the census for the area. I usually see a minimum wage full-time, as that seems to be the simplest way to calculate it, but there are options, and it is on the other parent asking for that imputation against the stay-at-home parent to prove any what that income could be if they're asking for something higher than minimum wage. That doesn't mean you have to go out and get a job, but what it does mean is that the court's going to assume that you can get a job in order to determine how much child support you would receive. And generally it is child support you're receiving. So one thing to keep in mind is that you may have an income imputed to you, but that doesn't mean that you're going to be the one with the child support obligation. If the other parent has a higher income and or fewer overnights, they will still generally most likely be the parent with the child support obligation. It's just that you have to have both parents' net income to get that total child support final obligation. Also something called retroactive child support. The court can calculate retroactive child support up to 24 months or 2 years prior to the date of the order that it is entering. It can only calculate that retroactive child support for the time the parents were not living together, because it is assumed that if the parents were living together, both parents were supporting the child or children. So it goes back 2 years or the time the parents separated, whichever comes sooner. It cannot go further than 2 years. So if you've been separated more than 2 years, all you can ask for is 2 years of retroactive child support. If you've been separated 6 months, all you can ask for is 6 months. The way retroactive child support works, they will calculate the monthly obligation as it should have been at the time, and then they will take the current monthly obligation that they've just calculated for the future and add a small amount of that to the baseline obligation until that total retroactive support amount is paid off, and then that small additional amount will fall off and they'll have that baseline obligation again. Child support can also be handled through the Department of Revenue Child Support Office without any other type of family case being filed. If the Department of Revenue, or DOR, is going to go after a non-custodial parent for child support on behalf of a custodial parent, what that usually means is that they have found out that the state is giving the custodial parent some kind of government benefits. food stamps or EBT, Medicaid, some kind of financial support for the family. And so DOR then will go after the parent who's not providing support to that family, because the state has an interest in the parents providing support to the children if the state is providing support to that family as well. If DOR is handling a child support case on your behalf and there is no other family case involved, they should calculate child support based on the actual time sharing that is happening since there's no court order. What they often do is calculate child support based on a 50-50 time sharing schedule. But what they cannot do is force parents to agree to a 50-50 time sharing schedule if you are not in agreement. And they also cannot handle contested time sharing cases. And so what they will do is calculate child support based on either 50-50 if everybody agrees, or what's actually happening, depending on whether those things are different. I often tell stay-at-home parents who are not quite ready to file something in family court that they do have the option to apply through the Department of Revenue's Child Support Office for child support, at least while they're waiting. One thing to keep in mind with that, though, is what I also often see is that if a parent who has sort of disappeared or not been super involved in the child's life then suddenly has a child support obligation through the Department of Revenue, they will then file some sort of family case, whether it be a divorce or a paternity case, to get a time-sharing order that may modify the child support obligation based on the overnights that are ordered by the family court judge. Once you have a child support order, you can request what's called an income deduction order. If the other parent works and they're not self-employed, the court can enter an income deduction order. It gets sent to the Florida State Disbursement Unit, and basically the child support gets sent directly from that paying parent's paycheck directly to the parent who should be receiving the support on some kind of card that you have to sign up for and get through the Department of Revenue Child Support Office. But it does eliminate the need to have the parents deal with each other in exchanging that support amount. And that way, if you are the parent that's receiving the support, you do not have to keep going after the other parent if they maybe are late with their payments or refusing to pay or whatever it may be. The Department of Revenue has a lot more enforcement mechanisms than maybe a private attorney or legal aid attorney in a family court. The Department of Revenue can get the parent who's supposed to be paying child support their driver's license suspended if they're too far behind on support. There are a lot of things they can do. So there are a lot of benefits to having DOR involved in a child support situation. So it's sort of up to you whether you want to reach out to them or not. One thing I will say is once they're involved, it is pretty hard to get them out of the case. So long as a family is at least receiving some kind of benefits, they are going to go after that other parent technically on behalf of the parent, but it's really on behalf of the child or children, so that they are receiving the support that they have a right to by Florida law. That is a very quick overview of child support. The Child Support Guidelines worksheet can be found online through the Florida Supreme Court Family Law Forms. It has instructions on it. You can review it and kind of see how the calculations are made and figure out what you think the number should be based on that worksheet. As always, I highly recommend if you have any specific questions about your individual case, you consult with an attorney so that they can apply any legal updates and specifics to your situation. Thank you for listening. Like, follow, subscribe if you are interested in hearing more about your rights as a stay-at-home parent or any other information about family law in Florida. Thank you.